Good evening, ladies and gentlemen. A warm welcome to all participants and viewers for this webinar titled as Supreme Court Order on Payment of Wages. Myself, Gopal Naik, working for More Retail Limited, formerly known as Aditya Birla Retail Limited. I will be the moderator for next 1 hour. Before we commence our session, I will have the privilege of introducing our eminent and key speaker, Suhas Tuljapurkar. Suhas is a practicing lawyer with over 37 years of experience. He is one of the leading lawyers of India in the field of corporate governance, ethics, compliance, and strategies. Suhas is also founder, director of Legasis Services and also managing partner at Legasis Partners. Suhas has been instrumental in developing various IT-enabled legal support solutions. He is an advisor to Digital Crime Unit of the state of Maharashtra, and he has drafted legislation for the state of Maharashtra also. He is truly a blend of lawyer cum technologist, which is a very rare blend, with a strong blend of lawyering knowledge and information technology. Suhas is able to develop solutions in the space of governance, compliance, CSR, so on. To his credit, there are many achievements, but I will quote a few, one or two, such as in 1987, Suhas pioneered in developing SC judgments database in DB language. He has been key member of a team that developed 39 GC processes for LPO readiness. More so, what I see, his hands-on experience as a corporate counsel. Today, Suhas is one of the most sought after business lawyer in India. With this brief introduction, I would request Suhas to take over and set the context for this entire webinar session. Over to Suhas.
Thank you very much, Meenakshi. Thanks a lot, Gopalji. Good evening to all the listeners. I think don't believe in what has been read out by Gopalji as my resume. I am a student of law, and I think we all learn every time something new happens in the legal space. So the better articulation is actually I'm a student of law, trying to learn with all of you together as to what's happening in this space. What we are going to do today is look at payment of wages as the issue and predominantly focus on what's Supreme Court's interim order, how it came to be passed, and what does it say. And in a sense, the Supreme Court itself in its own order says that wide publicity needs to be given to this order for its correct understanding. So Retailers Association of India, I'm very privileged to kind of present this webinar on your platform. This is in aid of whatever Supreme Court's interim order that talked about. What we are going to do is, I'm going to kind of take you through a short presentation, and then we will look at questions, and we will try to answer some of those questions. Through the dialogue, we will try and kind of evolve some of the issues that come to our mind. And I must say that with Gopalji, together with Gopalji, we'll try to make it as interesting as possible. I'm just taking the liberty of sharing my screen, please. So I think we are going to focus, because I think the focus is on the Supreme Court order, the interim order that has been passed, which is where I think we would like to look at. But before we go on to our main agenda, I'd like to express gratitude on behalf of RAI as well as on our personal behalves, our gratitude and a big thank you to all the doctors, the healthcare professionals, the law enforcement agencies, so what we call as frontliners and COVID warriors. I think there's no expression of gratitude is enough, because you are there and you are kind of working in the front end. We are all safe. the only commitment that we can give you from our side is that we will not do anything stupid to overwhelm the healthcare infrastructure. We would want to make sure that we will stay safe and we will not overwhelm the healthcare sector. So thank you very much. As typical as a lawyer for any of these webinars, I think I would like to put some caveats on record. This webinar is for general awareness only. Don't kind of look at this as a legal advice or opinion. Please seek a formal opinion based on your facts before taking any decisions. Okay. Secondly, the current situation is dynamic. It's uncertain, it's unpredictable, and therefore, risks that we may identify today, or we have identified today, or the risks that may remain unidentified at this point in time, this position may drastically vary in a short span of time. So I think don't go by what we are talking today, because I think there could be some judgment that may come up. There could be some legislative change that may hit us, and whatever we are saying today may not be valid tomorrow. So the point is actually, with the dynamic situation, with uncertainty and unpredictability, I think we are looking at what is the position as it stands today, and we'll try to explain this in terms of this webinar today. We're also looking at COVID-19. I think the world recognizes this to be a defining moment for local economies, for global economies all across. We may see a new set of laws coming into fold, which will have an impact not only local but have a global impact also. We will do in couple of areas today. We will take an eagle's eye view and we will delve into details. But this webinar is not an exhaustive kind of summary on the events or on the issues. Again, the views that we would be expressing, Gopalji would be expressing, and I would be expressing, these are our personal views. They do not represent our organizational view. So with those caveats in place, I would like just kind of look at today's agenda. And the picture that you see on the right is actually a future retail picture. I mean, how the people are going to kind of look at future retail. This is one articulation of the future retail. We will look at MHA Order of 29th March 2020, probably the most talked of order in the lockdown period, or right, even the declaration of a lockdown by the government was not as much talked about as the MHA Order of 29th March 2020 is being talked about. We will look at its validity or currently as it stands, and its withdrawal effective 18th of May. We will look at what were the challenges before the Supreme Court on the MHA order. We will also look at some of those contentions which have been raised. We will look at Supreme Court's order of 12th June 2020, which to an extent, gives some kind of clarification to us that we would be able to negotiate and settle. The order doesn't really mean that you pay to anybody and everybody, even though you may be bankrupt. It tries to create a balance. What does it mean is what we will talk about in terms of settlement and conciliation. And then overall, on an employer-employee relationship post-COVID, and now especially, how do we look at these relationships moving forward? Gopalji, if there is anything else that you would want us to cover, please let me know. We will try and kind of bundle this.
Sure.
So I think just moving on, and Gopalji, we've seen this. All of us have looked at these issues from the point of view of our own clients, our own companies, asking us, saying, please guide us in terms of what do we do now during the pandemic situation. Yeah. You see, on 20th of March 2020, so about 4 days before the lockdown was declared, the Ministry of Labor advised the employers, not to terminate the employees and deduct the wages. I think if you look at this, it was quite clear to us as students of law that this was advisory in nature. They said that yes, there is issue about COVID-19 pandemic, not pandemic or epidemic declared as pandemic by WHO, and therefore employer and employees will come under tremendous stress. Mind you, this was much before the lockdown, at least 4 days before the lockdown was declared. Ministry of Labor advised the employers, and this was through various circulars that came on administrative side, to say that please do not terminate the employees or deduct their wages. It was as simple as that, an advisory. I don't think any one of us, and Gopalji, you can correct me, I don't think any one of us ever thought that this is a law. We were of the view that this is advisory in nature. And we never kind of took it as it's a law through delegated legislation. I think then came this declaration under Disaster Management Act. Mind you, Disaster Management Act is a subsequent enactment, which 2005 enactment. And under the Disaster Management Act, invoking section 10(2), with effect from March 25, 2020, a lockdown was declared. Now, therefore, legally, Disaster Management Act, a special law considering or occupying the space of disasters, actually was invoked by the government, and lockdown was declared. On 29th March, now when you look at the kind of pattern that happened, from 25th of March, I think the establishments were locked down. They stopped functioning. They were forced to shut down. The work stopped at the project works. Everywhere, whether it was contract labor issue, whether it was migrant labor issue. I think by 29th of March 2020, we saw the employer-employee relationship getting completely strained. We were struggling. Mind you, we had done one webinar around 23rd, 22nd of March. That time, none of this was available, and we were trying to look at whether, based on the model standing orders, are there any provision which call for epidemic as a kind of a force majeure event, and what will be its consequence? Would it really result into stoppage of work? Would it really result into lockdown, or will it result into retrenchment? I mean, we were looking at all these various options, and then I think the Disaster Management Act was invoked on 24th of March, and on 29th of March, the MHA order that is impugned in the Supreme Court was issued by Ministry of Home Affairs. Now, Ministry of Home Affairs is the parent of ministry insofar as Disaster Management Act is concerned, and it invoked and it said that order of 29th March said all employers, be it industry or in shops and commercial establishments, shall make payments of wages of their worker at their workplaces on due date without any deduction for the period their establishments are under closure during the lockdown. And I think the subject matter of this order of 29th March was actually predominantly migrant laborers or migrant workers, which was seen as continuously stressed situation across the country, and was what seemed to be a very, very catastrophic event when it came to migrant workmen. Because the country was under lockdown, they couldn't possibly go back to their villages. They needed to be at their workplaces or in the cities where their workplaces were. They needed job security. They needed money because they were all kind of migrant workers paid virtually on number of hours that they worked. With that background, I think then what happened is various states started issuing the orders by taking cue, because this was MHA order given by the authority under Disaster Management Act to various chief secretaries and secretaries of various states.
Suhas ji, can I just interrupt?
Sure.
Yeah. I have, see, you rightly said that there is a circular by Ministry of Labor, which is of advisory nature. There is also this March 29th order. If you closely pursue this particular MHA order, it talks about only workers. Of course, there is a, say, migrant workers, whatever workers, it is only talks about. But when you look at the Ministry of Labor, it talks about workers, employees. So when you look at the Supreme Court also, in their discussion, they are also talking about trade unions, stroke employee associations. So there is one fundamental thing is coming up in the minds of most of the retailers, whether this is applicable to only the protected workmen or beyond unprotected workmen also. What I mean to say, is it a layman or it is also for in layman term, it is a blue collar and white collar, whether it is applicable to these both class of people.
Sure, Gopalji, my reading and my understanding is, if you look at the 20th March circular,
yeah,
you see, that's an advisory, and that talked about employers and employees.
Yeah.
So it was a broader term. It was not merely workmen, but employees all across. So, but that admittedly is not the law.
Yeah.
It's an advisory that was given via the administrative mechanism to say that you advise the employers that, don't terminate the employees, don't deduct their wages if someone, because of COVID, was not able to attend the office or the workplace, or come to the establishment or come to the factory.
Okay.
So actually speaking, that stands on a different footing altogether. It's not a law. Therefore, when it talks about employer and an employee, it considers not only employers and workmen, but it also considers other than workmen as employees in any establishment.
Yeah.
That has to be read as very, very broad kind of broad advisory, so to speak. But that's advisory. You see, that's not law. What is the law is actually the MHA circular or MHA order of 29th March 2020.
Yeah.
And that talks about, in clear term, workers at their workplace.
Yeah.
It talks about wages of their workers. I think some of these issues, what you raised, whether this kind of applies to employees, then the second question is whether it applies to contract labor.
Yeah.
Because I think they're not your workers. They are kind of contract labor and contract workers. So does it apply to them? Does it apply to migrant workmen at your site? So actually there are various contentions that have been raised in the Supreme Court on this issue. But the MHA, if you have to give the literary meaning to the MHA order, it only restricts to the workers and it does not go beyond workers.
Yeah.
You see, that's how we'll have to look at it.
Sure.
Does that kind of...
Yeah, because I only raised this issue because even Supreme Court, whatever interim order also, they talked about not only trade unions, employees association also. So I thought, is there some sort of interpretation? It goes beyond the protected workmen. That's how.
Yeah, I think this contention has been raised. The Supreme Court interim order, deals with this in a manner to say that these issues are open for adjudication.
Yeah, true.
Okay, but they are saying we will now restrict ourselves at the interim stage to what interim relief has to be given.
Sure.
Okay. So all these grounds have been raised in various petitions across the board.
Sure. Thanks.
So what is the challenge to this? They said, now there is no power and authority under the Disaster Management Act to issue such kind of order. Especially they said this order has been issued under section 10(2)L and there is no power authority. Now, whether you look at 10(2) and 10(2)L, both the kind of subsections there, the challenge has been, and as typically what we do, is that we actually challenge the constitutional validity of 10(2) and 10(2)(1) itself. There's a constitutional validity challenge that has been made. There is a challenge that has been made to say that there is no authority under the Disaster Management Act to talk about payment of wages, and that to payment of wages in this manner, which is to say that, okay, on the due date, without any deduction, you've got to pay them. So the challenge is threefold. Challenge is to say that 10.2 is ultra vires the constitution. It's not constitutional. Then there is no authority under the DM Act to pass such kind of order. And thirdly, that authority doesn't flow from 10.2, and you can't pass orders like this under 10.2, so that it is binding on everybody. So while these matters were filed at different point in time, there are various matters that were clubbed together. They were clubbed together. On 15th of May, I think Supreme Court granted an interim order to say that, because what had happened is between, let's say, March 29th, 2020 and May 15th, 2020, various state authorities, the field formations in the Labor Department, actually started issuing notices to various establishments saying, here is a MHA order under Disaster Management Act, and you got to ensure that all salaries are made, all wages are paid them. If you don't pay them, we will take legal action against you. We will take penal action against you. Some of the letters that we have seen actually threaten the employers to say that we will not only take whatever actions that are available under law for us, but if you don't pay this, we will do various things that you can't even imagine in short. You see, so these were kind of coercive letters, coercive notices that were issued by various field formations from the Labor and Welfare Department. So when this was brought out to the notice of the Supreme Court, and what happened is, various petitions got filed at various points in time. Each time these petitions got filed and the matters came up, a Supreme Court said, the government said, central government said, we need time to reply. We need 2 weeks to reply. So that 2 weeks time got extended from time to time because of various filings that happened. Then there are interventions that happened. So for adjudication of the matter, I think Supreme Court needed time to come to conclusion on adjudicatory issues. And in the meanwhile, I think these coercive letters had been issued. So Supreme Court on May 15 passed an interim order to say that no coercive action shall be taken against the employers, which actually meant that although this circular is there, this is the law that is holding forth today, but don't penalize people if somebody is unable to give effect to this order from MHA. Okay, now then come May 17, what happened is, you see, lockdown 4.0 guidelines came in. And lockdown 4.0 guidelines, which were again under section 10.2L of the Disaster Management Act, they said with effect from May 18, 2020, we have withdrawn all our earlier orders that we had passed under 10.2L. So that meant the March 29, 2020 order was valid and it stood withdrawn on May 18, 2020. So actually that's the purport. I mean, it starts off from May 29 and it ends on March 29 and it ends on May 17, 2020.
I have one question for this, Suhas ji.
Sure, sir.
After withdrawal of this MHA order effective 18th May by the central government, is it that Supreme Court would only consider and decide wages or whatever salary for 50 days? That means from 29th March to 17th May, or beyond that? What will be the position post withdrawal of MHA order in terms of employment terms also? Because see, there is a lot of confusion because even there are many questions have come, beyond 18th May, what would happen? So what is pertinent is whether Supreme Court will work within the four corners of this MHA order validity till the period of validity.
Yeah, I think if I read the interim order restricts itself now to the adjudicatory period between March 29 to May 17.
Yeah.
So the 50 days or 54 days of the lockdown, if you look at 50 days or 54 days maximum, is what probably that's the limit or that's the contour of the current cases that have been filed in the Supreme Court, and that all of them have been clubbed together. So I think they've restricted their, because I think when central government filed its affidavit on its own, they said that now we have withdrawn these orders. So to that effect, I think the list or the dispute or adjudicatory ambit is restricted to this period insofar as these Supreme Court matters are concerned.
So, I think they even said that academic interest only.
Yeah, they said that rest everything is of academic interest, therefore we will restrict it only here.
Yeah.
Now, having said that, Gopalji, very interestingly, you see, what was the employer-employee relationship from legal point of view prior to the lockdown? And what would be the employer-employee relationship post May 18?
Yeah.
I think same set of laws would apply.
Yeah.
Unless there are some state amendments that have come in subsequently. And we'll briefly talk about some of those state amendments that have come up.
You mean to say that post 17, that is 18 onwards, the employment terms or whatever IDA Act, whatever is there, that will prevail, whatever is there, which was prior to COVID period, right?
Correct. Insofar as retailers are concerned, I think insofar as matters under shops and commercial establishments are concerned, when you talk about things such as layoff, retrenchment, deduction of payment beyond what was permitted as the rights under Payment of Wages Act, all of them will have to follow the Industrial Disputes Act and norms under Industrial Disputes Act.
Yeah.
You see, to that effect, I think the law or the Supreme Court judgments are quite clear, including the Bata Shoe famous judgment, to say that when it comes to an issue such as you want to retrench somebody, you see, although you may be governed under Shops and Establishment Act, you are not an industry under Industrial Disputes Act. You are not one of that scheduled industry there, but still the provisions of Industrial Dispute Act would apply to such retrenchment, layoff, and various such schemes. Yeah. So to that effect, we will eventually have to look at Industrial Disputes Act and the legal principles around it.
Yeah.
So I think, as I mentioned earlier, I think the grounds of challenge for MHA order were, to say that the order is arbitrary and ultra-virus the Act and ultra-virus the Constitution. It's contrary to the fundamental rights under 1419(1)(g) and also 300A. So to some extent, I think this finds place even in the interim order passed by the Supreme Court. It says that the employer's rights are being violated and there are fundamental rights there. They talk about the businesses becoming unstable by virtue of this order, because no work, no pay is fundamental principle even coming out of ILO treaties to which India is a signatory. So to that effect, it's through the international treaty obligation that we have recognized no work, no pay as a fundamental issue. Now here is the situation where employers are saying we are unable to pay you because you are unable to work. Employees are saying we are unable to work because you are unable to provide us work. And this is kind of a logjam. And that's where I think various balancing acts are being talked about and being done. So from that perspective, I think the stability of business is what the employers are talking about. They are saying this is virtually forcing us into insolvency. You are saying I may not have revenues today. I may not be earning anything, but I have to pay to my employees whatever has been agreed even prior to the shutdown, prior to the lockdown. And I think to that effect, that stability and insolvency agreement is being talked about. They're saying government is forcing us to get into insolvency. That's another set of arguments is really to say that, government has accumulated various funds under various schemes, such as ESIC. You have, we all know BOCW, for example, is a cess available. There is a labor welfare fund available. So one of the very interesting aspects that everybody has been talking about is to say that 50 to 70% of the wage bill should then be provided by the government as aid to everybody. That's one of the prayers in these petitions. Some of the small players have actually said that we are not able to pay, but I think government, if it has declared the lockdown, government should be able to pay for these salaries and wages to the workmen out of the various funds that are available with the government. Now, therefore, these were some of the grounds or challenges for MHA order. Again, I think all the petitions were cut together, and one common affidavit has been filed by the Government of India. Government of India stand is that it has authority. Its order passed by MHA under 10(2)L of the Disaster Management Act is a perfect order. They're competent to pass this order in case of emergencies of this nature. And we have now withdrawn the MHA order effective 17th of May. So from 18th of May, this is not there. So they are saying now restrict it to only 50 days. Government's contention seems to be that if you assail government's authority and ability and competence to pass the order under Disaster Management Act, what will be the consequence of having passed all such or similar orders in various fields of law, in various fields of business function, including healthcare, by MHA under Disaster Management Act. So that's where they're holding the fort. The Government of India is trying to say that no, we're competent, we have full legal authority. These orders are virtually not contrary to the principles of fundamental rights. They are not ultra-virus. That's the major bone of contention insofar as current dispute is concerned.
So, Suhasji, if you look at from employers and employee perspective, both have competitive claims. While we say no work, no pay, is it not that workers are saying we have a right to work, but we have been prevented from entering to any establishment and all this because of this circumstance? So, is it that government is bound to compensate in a big way because it is ultimately the lockdown is brought by government? So is it not that? Because why I'm talking about this, if you look at various countries, they have come out with so many schemes where in such a lockdown condition, they have given 70%, 80% add to the most of the industries. So what is your view on this?
You see, currently, if you look at the current scenario, and we'll talk about it subsequently, is I think almost about 23% is the rate of unemployment today in April and May. So unemployment is increasing. Now, I'll come back to CMI figures around that. But on one hand, you're seeing the unemployment rising up. So probably 1/4, if you're talking about almost 25% of the workforce remaining unemployed, you're talking about 1/4 employed population remaining unemployed in India today. These are CMI figures. Now, where has this come from? This has predominantly come in April and May because of the lockdown.
Yeah.
Therefore, employers have also gone and employees have also gone in almost about 1/4, 25%. The overall economy, it shrunk again by almost 30%, 35% for sure in these 2 months, April, May for sure. So actually in this kind of a thing, you are absolutely right when you say that there is a lot of balancing act that will be required to be done. And in the balancing act, if government has funds available with it, why can't it pay to all the employees? I think that's a fundamental issue. these are some of the areas where I think ILO tried to do and tried to guide various countries on what it needs to be done. There are various, multilateral institutes such as World Bank, IMF that have come out with various schemes by way of which you will actually try to rejuvenate the economy and try to see whether this stress can be reduced.
Sure.
However, saying that government will pay for your employees just because government declared a lockdown, I don't think government is accepting this argument. For one reason, they are saying there is a larger public interest, which is the health of individuals. And that's why we were forced to come out with this order of lockdown. So it's in the larger public interest that the government came out with the orders such as lockdown or the MHA order of 29th March. That's the broader principle.
Sure.
Okay, so some of the grounds in support of the MHA order is that, very interestingly, that they are saying right to wages is a pre-existing rights under labor laws. And therefore, it does not really harm. It is not contrary to Articles 14 and 21 of the Constitution, 14, 19, 1G, 21. Because these laws, we talk about right to wages, right to work, is also a fundamental right. And that came from, these laws have come and they have emerged from Articles 14, 19, 1G and 21. They're not contrary.
Sure. Thanks.
Under 72 of the Disaster Management Act, the National Disaster Management Authority, the 72 says it has an overriding effect. It means what? It says that the orders under Disaster Management Act passed by competent authorities will have an overriding effect over any other law which is inconsistent or any other action taken under the law, which is probably inconsistent with what has been done under NDMA, Disaster Management Act. In the event of that inconsistency, Disaster Management Act will override any other actions. So that overriding effect is an argument which is being put forward today. As I said earlier, I think it's in the larger public interest. There is no arbitrariness involved in any of these orders that have come.
Sure.
Also, one of the arguments is these are temporary measures to kind of mitigate the hardship which is caused to the laborers and the employees. And of course, it limits only to 50 days now. Luckily, that 18th May onwards, this MHA order doesn't hold fort, so to speak. So to that effect, these were some of the grounds or counter arguments that were made on behalf of MHA. What does Supreme Court do here? Okay, initially, I think the interim measures were announced of no coercive action to be taken. This interim order that came in now talks about the matter being heard in July, because there was only limited counter affidavit filed by government of India. So they said, we will only talk about these 50 days. And as you rightly said, they said it's of academic interest now to talk about larger issues. So we'll not get into that. Because now that from 18 May onwards, everything is going to come back. And this is not a subject matter of dispute here. What it recognizes, what the Supreme Court order recognizes, is they say that this is industry needs workers and workers need industry. Employers need employees. Employees need employers. So this is mutual. Now, when you're talking about returning to work, this mutuality has to be recognized. And it has to be recognized to the effect that unless there is a congenial work atmosphere and both the sectors come together and find a solution, you're not talking of very amicable way in which there will be restructuring, there will be reopening of workplaces. Yeah. And that seems to be the overwhelming reason with which I think the government the Supreme Court actually looked at these interim measures and gave a direction. I'm going to request you to bear with me for a minute, because what I'm going to do is I'm going to read out from the Supreme Court order itself in terms of what is meant. What are the kind of interim orders passed by the Supreme Court? Okay, so I think interim measures can be availed by all the private establishment, industries, factories, workers, trade unions, employee association, etc. Okay, and they're saying that the state authorities will facilitate these interim measures. This is of a great importance, because you see, then when we look at the other laws, and I'll come back to that as to how this becomes a force of law today, when we talk about these interim measures moving towards a final settlement. And the first interim measure directed by the Supreme Court is that the private establishment, industries, employers who are willing to enter into negotiation and settlement with workers stroke employees. And Gopalji, here is where I think the difference is being drawn.
Yeah.
To say that worker stroke employees is probably being used very synonymously.
Yeah.
So the distinction between what we understand on a threadbare reading of law, such as the labor laws, is to say that workmen is different from employees.
Yeah.
Employees is a broader category, but workmen is a limited category that's protected under the laws. Probably this seems to be going on the presumption that these are synonymous. And I'll read this again. The private establishment, industries, employers who are willing to enter into negotiation and settlement with workers, employees regarding payment of wages for 50 days, we explained that, or for any other period as applicable in particular state during which their industrial establishment was closed down due to lockdown. Now, in some of the cases where it was in green zone, there was no containment, it was in the green zone, broadly speaking, when lockdown 2.0 onwards zoning started happening. You could open up your industrial establishment, you could open up your office, you could open up your factories. So to that effect, they are saying 50 days or for any other period as applicable in particular state during which their industrial establishment was closed down due to lockdown, may initiate a process of negotiation with their employees, organization, and enter into settlement with them if they are unable to settle by themselves, submit a request to concerned labor authorities who are entrusted with obligation under the different statute to conciliate the dispute between the parties, who on receiving such request may call the concerned employees, trade unions, workers association, workers to appear on a date for negotiation, conciliation, and settlement. In event a settlement is arrived at, that may be acted upon by the employers and the workers irrespective of the order dated 29/3/2020 issued by Government of India, Ministry of Home Affairs. So this is the first directive. It calls upon people to say that this order, neither does this matter pending in the Supreme Court, will come in your way of trying to work out a negotiated settlement with your employees. I think that is the first direction. Second is those employers and establishment and industries, factories, which were working during the lockdown period, although not to their capacity, can also take steps as indicated in direction 1. So even though you may have been an essential supplier or essential manufacturer, so the essentiality allowed you to continue to run your establishment, even though you have a dispute or you have this issue about there was no full capacity to function. and therefore you couldn't pay as much salaries as you had agreed or contemplated. Then also you can enter into negotiations, you can get into settlements, and nothing that will come in the way of your settlement. You pay as per your capacity. The third direction is that private establishment, industries, factories shall permit their workers stroke employees to work in their establishment who are willing to work, which may be without prejudice to their rights of workers and employees regarding unpaid wages of above 50 days. Now, what does this mean? This actually means that please do not say that you have not agreed on our stand with respect to 50 days lockdown period on payment of wages. Therefore, you will not be allowed to work any longer within our premises. So all those types of excuses will not come in the way, and that the private establishment shall permit workers, those who are willing to come to work. That's a very positive direction from Supreme Court, a mandatory direction, if I were to read it that way. So while the workers on the payment of wages for 50 days might still be negotiated, still might be negotiated or adjudicated, I think the private establishment industries and factories have been mandated to permit the workers to provide work without prejudice to the rights of both the parties in that sense.
So what I understand from Suhas ji, arising out of this settlement, it will have a legal force. That is, legal backing will be there, and it overrides MHA order also. That is what Supreme Court talks about, right? That is what.
Supreme Court doesn't say it in so many words that it will override.
Yeah, no, that is what we can see that. No, otherwise they will not ask for negotiation or conciliation. My one question is that when Supreme Court is expected to hear this matter somewhere in the last week of July, don't you think the duration available is very short for such kind of settlement or negotiation, particularly when there are many private organizations or establishments where there is no such association or trade union? So how does it will happen? Because if suppose, I know it may take some time for Supreme Court, although 4 weeks have to be filed, and I don't know whether Supreme Court is trying to balance further by taking some more time. What would be the outcome of this? How do you negotiate with? That means you have to go each employee and talk to him, because it is difficult where there is no union, there is no association. So you have to collectively cannot do that. You have to go by employee to employee. What is your view on this?
No, I understand that the time may not be enough, but although this order, the next date of the hearing is posted somewhere in the last week of July. However, by then we don't know what is going to happen. It's not kind of a preemptory date when these matters will come to end. Okay. Or the adjudication will be finally heard. Not too sure about it. As kind of practicing lawyer, we all know what happens at any date, there is uncertainty. And to that effect, therefore, even if you have shown bona fide way in which you have tried to negotiate, but the settlement hasn't been arrived at by then, I think you still would be in a good position to convince the courts to say that we made a bona fide attempt to cover this up and get into negotiations. You see, therefore, that's one area. You see, then there is a third kind of direction that is issued to say that the private establishments, factories who proceed to take steps as per the directions, which is number 1 and 2 that we read out, shall publicize and communicate about such steps to workers, employees, for their response and participation. So, Gopalji, understanding where you're coming from, you may not be able to, get into settlement, and 2P settlement is an individual settlement with workers. You may, if you publicize saying these are the steps that we are taking, this is the negotiated settlement that we have arrived at with few employees. Now we are trying to talk to you to kind of arrive at a similar settlement. I think that kind of bona fide attempt is what is contemplated by the Supreme Court. They are saying, please give, please communicate, please publicize all such steps that you are taking for a settlement. And this settlement, they're saying, shall be without prejudice to the rights of the employers and employees, which is pending the adjudication.
What Supreme Court is really looking for the best efforts to be made by both the parties. That is
Correct.
what they're okay. But I will ask one sharp question to you. What is your gut feeling whether this negotiation process will yield desired result?
Sir, I mean,
your gut feeling, your personal this thing, of course.
No, you know this, you know. See, we have had toughest of the negotiations when it came to labor unions on the other side. You see, I mean, in a very clear bona fide manner, in a matter of 1 month to 2 months, an employer and employee, the worst possible dispute could actually be result into a negotiated settlement if the parties are genuine and bona fide. In this case, I believe, because there is a stress everywhere, I think people will come around for a very reasonable solution. Both the sides will come to a very reasonable solution. Now, you may not have that settlement that you have with the union, but 2P settlements, which is the individual agreement, otherwise than in a dispute situation.
Yeah, what I can say that both employer and employee are right in their perspective, and they're also wrong in their own perspective. So therefore, I think it is one of the best way I think Supreme Court has directed for negotiation, because everybody understands the situation, both the sides. I think it is a very good balancing act the Supreme Court is doing.
No, absolutely. Therefore, I'm of the view that if somebody wants to work out these solutions and settlements, I think, yes, it is possible to do that. Therefore, you can continue to work without prejudice to your negotiations. You may take some more time. Now, amicable settlement in a balanced position, and Gopalji, you're right. I mean, there is always this tussle and there is always this tug of war. Yeah. I need more and I need less. However, we look at the definition of settlement under the Industrial Disputes Act and then give effect to it. Why I am saying take shelter under Industrial Dispute Act is the moment you go there, there is a settled series of case laws available as to if a settlement is arrived at in terms of Section 2P, which is the definition of what amounts to settlement, and Section 18(1) of the Industrial Disputes Act, together with various state rules. Each state would have rules. Somewhere it is Rule 57, somewhere it is Rule 62. And there is a form by way of which you record the settlement, which is you give a cost title of the settlement, you record your terms of settlement, you record the signature of the employer and employee and 2 witnesses there. It's as simple a form of that, and file it with your conciliation officer, labor office. Sure. If you get into this settlement, there are settled case laws saying the courts will not interfere on the merits of the settlement, on the quantum of the settlement. So long as the terms of the settlement are not illegal, in a sense they do not impinge on any other rights and legal provisions. They are fair, reasonable, and there is no discrimination. That on the record you can show. There are these various judgments from High Court onwards and Supreme Court as well that say that if this settlement is arrived at, the courts will not get into it so long as it's fair, it does not kind of breach any other provisions of any other labor laws, and it's non-discriminatory in nature. Sure. Therefore, culling out from the Supreme Court interim order and looking at Industrial Disputes Act 2P and Section 18(1), I think we would be able to come out with a very fair, a very reasonable and very balanced settlement, which even if you are negotiating when the matter comes up in July in the Supreme Court, your bona fide attempts, I think you will be very, very better placed of saying that here is a balanced approach that we are taking. Sure. So we see as we move forward, we see that what happens beyond lockdown now. So on one hand, if you look at 2P settlement happening for this 50 days period, nothing prevents you from looking at and getting into 2P settlement, individual settlement beyond 50 days period. Sure. Because if you actually look at individual settlement for the entire duration of, let's say, pre-lockdown, let's say beginning of March, till now, or till whenever you are able to function with 100% capacity, let's put it that way. If you can work out a settlement with your own employees, now that is something where a new normal is going to emerge, because there is a change in the way we are going to work hereafter. You see, as I mentioned, I mean, if you look at the unemployment ratios declared by CMI, you're talking about in March 20, it was 8.75% was unemployed. So for every 100 employed people, 8.75 people were unemployed in the month of March. Look at April and May, you're talking about May to be under 23.48, and I think April was little more than May. It was almost 23.75 or 74. So that's the kind of unemployment that we are facing today.
Suhasji, we have got time paucity.
Yeah,
Can I take two quick questions, short questions?
Yeah.
So large number of participants are asking, during lockdown period, since there was no revenue or income, or there is very less income, whether employer is obligated to pay wages, salary, and what is your advice?
See, I'm saying, what is your strategy post lockdown?
Okay.
Are you able to function? You want to function. You want to continue to do the business. Therefore, you will need your employees. You will need your workers.
Yeah.
In that scenario, you must make sure that you arrive at a settlement with them. Whatever you are able to pay now, you should be able to pay. And you should come to terms with them. If you are unable to pay at this point in time, then you will have to go back straight forward to say that we are unable to pay. Otherwise, the businesses will get wound up. And if that is the situation, then still you will want to get into settlement with individuals, settlement with your own workers, and come out with a formula. Now, each one will have different stress. Each one will have a different financials for these kind of settlements. But you can still work out, even though in some cases you may say, sorry, for this three months period, my revenues have been nil. Please accept nil as a payment. And if the employees agree to that, you may still be able to work out a solution and move forward.
There's one more question. During this particular lockdown period, many have paid in terms of some allowance, COVID allowance, advance, in various forms. So whether this can be adjusted against wages, depending on the settlement or depending on the Supreme Court final judgment.
Yeah, I think you would be able to consider this as ad hoc payments made. If you paid in ad hoc manner, you would be able to true it up. You will be able to true it up as and when you enter into settlement. And based on that true up mechanism, then you will talk about what are the deductions that are required to be done. So it is possible that you get into making these payments as ad hoc. I wouldn't call them ex gratia. I would still kind of want to articulate them to be ad hoc payments, and you will give a treatment at the end of the period, whether it is June end or whether it is July end, depending on when you are able to function fully.
There is one specific question: can employers send employees on forced leave without payment in the current situation?
See, there is no law. This comes under furlough.
Yeah.
There is no law relating to furlough in India. There is no mechanism by way of which you could do that. However, as I've kind of tried to articulate here, there are state amending laws that have been passed by UP, MP, Rajasthan, Punjab, Himachal, Gujarat, and Odisha.
Sure.
Which amendment laws today are talking some furlough matters. They are also kind of referring to, let's say, your number of hours increasing from 48 per week to 72 per week. And those amending laws are trying to bring in that flexibility and informality, which, they will have to be tested differently by the courts of law on their own merits. But those state amending labor laws try to do this, like the furlough arrangement, to say that, okay, you adjust this against first the paid leaves, then make them unpaid leaves, etc. I think there is no mechanism today, even if you were to stretch the provisions of the Model Standing Orders Act relating to stoppage of work to say that now you consider this as paid leave, unpaid leave. I think I would not advise that course to be taken.
Okay, thanks for that. One more last question I'll ask you. What would be the position if statutory amount like Provident Fund, ESIC amount is not paid by the employer during the lockdown period? Is this amount to be deposited, or if so, when? And what could be the consequence if not paid?
See, at least to the extent that you are paying ad hoc amounts, I think it is advisable for you to, deduct your statutory deductions based on those ad hoc amounts and deposit it as ad hoc payments. There is a provision under which you can still deposit this as ad hoc payments.
Okay. And
then do a true up when you have ability to come to settlement, and that true up will be accepted by the authorities.
Okay. I think we have already reached 6 o'clock. I must say, you have anything to share? Something? Okay.
Yeah, very quickly. I think what we are trying to do is we have a risk management tool which somebody can access and look at what risks that the businesses have, small, big, and this is all a pro bono initiative from our side. We also have a resource center by way of which we have created a comprehensive repository of almost about now 1,000+ notifications, judgments and advisories issued by various governmental authorities in India. We do, of course, the webinars with RAI, NOSCOM, NCCI, BCCI, Producers Guild, Bombay Stock Exchange. And we are happy to kind of extend our knowledge series. We work with Boom Fact Check to kind of look at what are the fake notifications during this period. We have seen there are lots of, even the government orders looking like as though their authentic government orders have come out, which were actually fake orders. Every day at 6 p.m. we have a call with our clients and with our prospective clients to share the updates that are happening on law. We are being approached by various clients to look at moving the authorities to get the extension of dates and notices, etc. We've created a contract solution, which is an online legal advisory solution. We've created SOPs for somebody who wants a help on checklist and going back to work. So these are some of the initiatives that we have. So Back to Work is a portal you can actually sign up and look at what would apply to you. This is a platform. And I would say thanks for patiently listening to me, and stay safe.
Suhasji, thank you so much for being with us for this webinar and sharing your wide experience. I think you have provided a lot of insights for us. I think it will be very, very useful. And before we conclude this session, if anyone has got further query, they may write to Retailers Association of India, and the mail ID will be gautam@rai.net.in. Once again, I repeat, Gautam, GAUTAM @rai, RAI.net.in. Thank you so much. Thank you so much for the RAI also for organizing this platform. Thank you once again, Suhasji.
Thanks a lot, Gopalji. Thanks a lot, Meenakshi.
Thank you.